topics and opinions expressed in the following show are solely those of the hosts and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert show on W4CY Radio and Talk4 TV, where we bring you educational information from top local experts in the fields of legal, health, financial, and home improvement. Now sit back and listen to experts in family law, association law, hearing loss, business brokers, home care, along with many other topics. Now here are your hosts, Steve-O and Sophia.
Hey, good afternoon. Welcome to another Ask the Expert show where we bring you the top experts in the field of, got ahead of myself, legal, health, financial, and home improvement. I'm your host, Steve-O. This is our 12th year of Ask the Experts. We do about 50 interviews a week. And I got to tell you, once in a while, you have an interview where the expert and yourself just click. And this afternoon, we've got one of those. Hope he doesn't get the big head over this, but I love interviewing attorney Alan Swartzide with the K. Bender Rimbaum Community Association law firm, who've actually been with us since day one. It was about 12 years ago that we started with K. Bender Rimbaum. But today's show, I love interviewing. I love the way he relates to the audience. Let's welcome attorney Alan Swartzide.
Thanks, Steve. Appreciate you having me. Appreciate the kind words of introduction, which is much better than I get when I'm working with Jeff Solomon.
Hey, how about Rimbaum?
Oh, Rimbaum wouldn't even introduce me. He'd just say, yeah, here's my guy.
Well, you know what? You can tell by the amount of letters, emails, texts that we get. People love your show, and we've really developed into something really nice. We get so many people now that say, hey, I just found your show. How long have you been doing the show? So for all those new people out there, tell everybody about yourself and about K. Bender Rimbaum.
Sure. Well, again, my name is Alan Swartzide. I'm the managing partner of our firm's Orlando office. My office is right next to UCF, if that means anything to most of the people that are attending in Orlando today. We work throughout the state, both my office and our firm. I've got clients between Perry and Miami. We've got 4 offices of the firm. One's in Pompano Beach. We've got Tampa. So we have a good presence in that area as well. We've got Palm Beach Gardens and Miami by appointment. 22 attorneys. Literally all we've done since the 90s is represent community associations. You know, we've maybe taken on the rare individual client who really needs a little bit of help, but 90 to 99% of what the firm has done since the 1990s has been representing community associations. So, you know, we don't have a minimum criteria. We don't use annual fees except for our special collection program. We don't have monthly minimums. If you need help, that's kind of what we're here to do. And we try and get a little bit more creative than a lot of other firms. I made a joke on LinkedIn the other day where it was basically, you know, the joke, a good lawyer knows the judge, a good lawyer knows the law, a great lawyer knows the judge. My comparison was a good lawyer knows the law. That's the basics. A great lawyer knows how to, I won't say manipulate, but maybe work with the law to the extent of almost always being able to say yes to a client. Just maybe, okay, well, you can't do it the way you wanted to do, but here's 5 other options that might accomplish the same thing. The other thing that I think sets our firm apart from pretty much any other firm in this sphere, so to speak, is that we really do care about our clients enough to provide a response or at least acknowledge that we've heard from you within one business day. You're not going to wait 3 weeks to have us acknowledging, yep, got your question, and then another 3 weeks to have us get you the answer. It's going to be, at least in my office, and I believe in all of the other offices of our firm, all the attorneys, all the paralegals, within one business day, unless we're out of the office, you're going to hear back from us saying, got it, we're working on it. So I think that's kind of an explanation of how the firm operates, but we do find educational programs like this, and the one that I finished literally 20 minutes ago for HOA's board certification course. We just find that education really important, and that's part of why we love working with you, Steve, because we get the opportunity to help some people that frankly want to avoid some attorney's fees and get some quick answers. I can't give legal advice if I don't work with your community, but I'm happy to give the education as to the status of the law and what you might do in situations that you find yourself in. So I think that's enough of a soapbox for me for today, Steve.
I hope that we still got 40 minutes left. We get so many letters from your clients that listen to the show and who tell us how pleased they are with your representation of their community. And it's the other way around. But with K. Bender Rimbaum, we get so many letters from your clients going, thank you so much. We love the show. And we've got, I cannot tell you how many ladies' card rooms that have played their cards this time of day who turn it on in the hall to listen to the show. That's amazing.
Yeah, I mean, I certainly appreciate that. And listen, if that's what they choose to do while they're playing cards, I hope they're mostly paying attention to the cards, because I can almost promise you that's going to be more interesting than anything I have to say. But you know what? Listen, there are a lot of people that are on the board and actually care enough to take classes, listen to shows like ours, and try and get the education that really isn't offered anywhere else.
Well, we've got a ton of people waiting to talk to you. Let's go to our first one. Do Florida statutes require meeting minutes be taken at all closed condominium board meetings? Nothing in our documents address that.
Generally speaking, yes, there should be meeting minutes of every meeting, including closed meetings. Closed meetings in a condo are generally going to be the ones that are attorney-client privileged, or where the board is talking about employee issues, personnel issues. Those still need to have meeting minutes as to what was voted on, what the discussion was, what the decision was. Well, let me step back. What was voted on, who made the motion, who seconded it, etc., but not any of the discussion that was had. So you're basically just reporting the outcome of the meeting. There are some circumstances where those minutes aren't really feasible, because anything that you put in there would be breaching the attorney-client privilege and would waive the privilege. So it really just depends on the circumstances. And it's funny because I literally just read through the entire condo and HOA statutes last week, as boring as that is for me and everyone to hear about it. But I don't recall offhand, and I'd have to do maybe 5 minutes of research to make a determination of whether the meeting minutes are required under the statutes governing condos, or if there's something that's under Chapter 617, which is the Not-for-Profit Act. And both of those are generally going to apply both to an HOA and a condo. Well, let me clarify that. 718 is going to apply to a condo. 720 applies to HOAs. 617, the Not-for-Profit Act, applies to both. So the answer is, I don't know offhand.
She's got a follow-up, or he's got a follow-up. Once all litigation has been settled, are the condominium owners allowed access to the closed meeting minutes relevant to that? Are there any exclusions?
That, frankly, is going to depend on which attorney you ask that question. My opinion is that privilege extends indefinitely. Because if someone tries to say, okay, well, the litigation's over, I want to get all these documents, I want to get all this information, I want to look at it, And the bottom line is that doesn't mean that that litigation won't be reopened at some point. And frankly, I've seen owners try to get at that information specifically for the purpose of reopening the litigation and using the attorney's information against them. So, from my perspective, and I know not all attorneys agree with this, that information is protected from attorney-client privilege unless and until the board waives the privilege, not until the end of the litigation. But I know that there are some people that will say, some arbitrators that will say in condo context, that that information is subject to disclosure. I just don't understand that concept of saying, well, there's been a judgment entered. Now all of the privilege that the association enjoyed just disappears. But an owner can try and vacate a judgment 5 years later if they argue that the judgment is void. So it just doesn't make sense to me to say that privilege only extends until the end of the litigation or until the litigation is settled. That settlement agreement, that judgment don't end the risk that is associated with giving up that privilege.
Okay. Our next question from the chat line is, does a condo association have to post a paying position that is available, and how long should it be posted?
I'm going to be candid. That is 100% an employment question. There's no statute regarding condos that governs that. Your governing documents probably don't even talk about it. The only thing I can think of that you might be referring to is the requirement to post bids for certain contracts with the association. If it's an employee, that doesn't apply. That requirement to get 3 bids, if it exceeds, I think it's 5% of your annual budget in a condo, that doesn't apply to employees of the association. It doesn't apply to certain professionals like managers and attorneys and engineers and architects. So if that's what you're referring to, then no, the association doesn't have to obtain those bids. You can just hire whoever you want as long as they're the best person for the job, in your opinion. But it might be a separate employment issue I don't know about.
Okay, we're going to stay with the chat line.
Okay.
This person is actually, it's an honor for him to be listening and have his input. He's a lot of times he's responsible for working with the legislator up in Tallahassee. He wants to know how will the DBPR enforce the structural integrity reserve study requirement? Will associations have to submit only information regarding the completion of these studies?
So how the DBPR will enforce it is really going to be up to the legislature to kind of clarify, and it's going to be up to the DBPR to kind of put in place specifics as to what they intend to do if someone violates some of these things. The requirement itself, if you breach it, is a breach of fiduciary duty. Whether the DBPR is going to enforce that or a court of law, I can't say offhand. Frankly, it's going to depend on how that claim is raised by the owner who is arguing that the board of directors was obligated to complete this requirement. So I don't have a specific answer. And Steve, if you can put up, because I know there was a second question that I haven't yet answered, but the bottom line is it's going to be up to the DBPR and the legislature, and hopefully the people that actually are involved in making these decisions on behalf of the legislature will consider this question, because I think it's a good one. Will the association have to submit any information regarding the completion of these studies? I don't recall candidly offhand whether that's required right now. But if it is requested by a local enforcement agency, meaning usually your city or county, that's a response that, yes, the association is going to have to submit. I have a feeling if it's not already required, then you will have to include that as part of your annual filing with DBPR at some point in the near future. It would surprise me if the legislature didn't put that type of requirement in place if it's not already there. And again, I just don't recall offhand whether it's required.
Okay, again, staying with our chat lines, pretty much full today. Shouldn't minutes regarding votes on a contract include vendor, terms, contract, prices?
Well, I mean, presumably you've already got your agenda that attached a copy of the contract, or you've got that information listed elsewhere. If you're talking about limiting the board's authority to contract with this vendor to a certain dollar figure, certain terms that are not already in that contract, then you might include that in the minutes. If the board basically decided, well, we're going to go with this vendor, but their terms and conditions that are in the contract, their contract price are not acceptable to us, then the decision of what might be acceptable, yeah, that might go in the meeting minutes. But generally speaking, you've got your signed contract. I don't know why you would need, other than to prove that the specific contract was the one that was approved. I don't know why you would need that information in the meeting minutes unless it was something specifically included in the motion when you were voting on the contract. But usually you would just say, we vote to allow the president to sign the contract between the association and this vendor that was provided to the association and dated on this date pursuant to a bid, whatever that information may be. It's not commonplace in my experience to include that specific information unless there's a specific reason to.
Hey, if you'd like to call in, the phone number here is 561-512-2883. This is K. Bender Rimbaum. They're community association lawyers, one of the largest in the state of Florida. Let's go to our text. I know how important education is to the K. Bender Rimbaum firm. From what I understand, there's going to be mandatory educational information for HOA board members as soon as the governor signs it. Any truth to that?
It's being passed through the legislature, and good Lord, do I hope this gets approved. Because the bottom line is, the more people that are actually educated and do the right thing, the less situations like the hammocks down in Miami and things like that you're going to see, because people know what to look out for in those types of situations and potentially avoid it. But yeah, the short answer is yes, that is going through, and I really hope that it does, because it's the education piece is something we've been pushing within the firm. I know myself, Mike Bender, Jeff Rembaum, we've been saying it should be necessary for you to kind of have at least some idea of how to run a not-for-profit corporation, which is what you're running as an HOA, before you're able to just make decisions for a multi-million-dollar business. Because let's be realistic, look at your budget. Whatever's in there, however many dollars, that's the dollar value of the business that you're running. So if you're sitting there and running a business with a budget of $500,000 and you've got no experience in business, no experience running a community, and no knowledge because you haven't done any education, you've got a really good chance of putting your community in trouble. So the goal here is to make sure that rather than just signing a piece of paper that says, I read the governing documents and I'll do my best to do what they require, which is the alternative right now, it would be that you sign that piece of paper and you take a class like the one that I literally taught less than an hour ago that shows you kind of the very, very, very basics of how to be a good director, or at least how to be a director.
Rex in Longwood wants to know, is it really true that no more than 15% of the units can be rentals?
Frankly, that's going to depend on your governing documents. I mean, I know of communities that I work with in an HOA context in Kissimmee where 100% of it's rentals. There's literally no one that lives in their lot. So it really depends on what your governing documents say. If they say no more than 15% can be rented at any given time, then the association should be sticking to that. If they don't say anything about leasing or renting, there's no restriction whatsoever.
We're getting ready to go to break. Before we go to break, Alan, let's give everybody the schedule that's coming up for the month of March regarding your classes.
Going to be a busy month as usual. We've got on March 1st a Venice Lunch and Learn at Venice Golf and Country Club with Kirsten Henza of our Tampa office, my good friend, and I know you know her as well. We've got on Wednesday, March 6th, Emily Gannon of our Pompano office is going to be teaching fair and consistent HOA violation enforcement along with affinity management We've got CAI FLA legislative update, which I think is going to be an important one by Lisa McGill of our Pompano office on March 15th. We've got a Miami-Dade happy hour with class at Ruth's Chris in Coral Gables. Sounds like a good deal to me. I almost wish I could drive down there or take the Bright Line and just join Mike Bender at that one. That's going to be on March 19th. We've got the screening process, develop procedures and train your committee. That's going to be on March 20th with Allison Hertz of our Palm Beach Gardens office. HOA board certification with Danielle Brennan, also Palm Beach Gardens, on March 20th. Community Association collections with this guy, Alan Schwartzide, you might have heard of, on March 26th. Andy Black doing a condo board certification on March 27th. And funding construction projects with Kirsten Henza on March 28th. And I will be 100% shocked if that's actually all we end up doing by the time March is over. Because we always have someone that reaches out and says, hey, would you like to do a class on? And our answer is almost always, yeah, let's do it. Sounds great.
I just want people to know that there are a lot of law firms that do certification classes, but at K. Bender Rimbaum, they go so far beyond that. They have so many free classes each month, and plus they give up their time to do the show here in Tampa and South Florida. I just think it's so incredible what K. Bender does as to educating people.
Well, listen, I really appreciate that. I mean, we don't do it for the recognition. We do it for the education, but I certainly think it's important. And it is nice to hear that people actually realize how important we find this and the efforts that we're making in any given month to give up the attorney's time, give up billing, and make sure that people learn something here and there.
We're going to go to break. Alan, give everybody the main number that's good for all the different markets.
Sure. The easiest number to reach anyone in the office or any office of our firm is 954-928-0680. That's 954-928-0680. Easiest way to reach me personally is going to be email as@kbrlegal.com. And feel free to check me out on LinkedIn. I do try and post something every day, either a helpful hint for attorneys, for managers, or for anyone in this industry. I generally keep it specific to the industry or specific to the classes we've got coming up or about me.
We're going to go to break. Their website is www.kbrlegal.com. We're going to go to break. When we come back, we have more with attorney Alan Schwartzide.
K. Bender Rimbaum is a full-service community association law firm dedicated to the representation of community associations throughout Florida. On kbrlegal.com, you can learn more about their offices in Pompano Beach, Palm Beach Gardens, Orlando, Tampa, as well as throughout Miami-Dade by appointment. Several K. Bender Rimbaum attorneys are board-certified specialists in condominium and plan development law and assist clients with all matters of community association legal issues while keeping them up to date on new developments that affect their associations. K. Bender Rimbaum is also a well-known provider of free legal education for managers and board members. Contact K. Bender Rimbaum today by calling 800-974-0680. That's 800-974-0680 to reach any of their locations. You can also visit them online at kbrlegal.com or write to them at info@kbrlegal.com.
And we are back with the Ask the Expert show on W4CY Radio and Talk4 TV with your hosts, Steve-O, Sophia, and their expert guests.
And we are back. We are here with attorney Alan Schwartzide. This is the K. Bender Rimbaum Community Association law firm. And we take, if you're watching on TV, we have a chat line, which many of you are taking advantage of. You can also text us at 954-336-3767. You can also call us here. Phone number here is 561 512 2883. And you can always go to K. Bender Rimbaum's website at www.kbrlegal.com. Alan, I got to tell you, we are getting a lot of people that I guess I don't know how they're finding out, but apparently there's a lot of HOA potential statutes, laws that are getting ready to change. And normally it's condo, but suppose there's a lot of them waiting for the governor to sign. Have you heard that?
Yeah, I mean, there were a bunch of bills this year. There's definitely a condo bill that is kind of in line with some of the things that we've spoken about multiple times in the past regarding what Barry brought up with structural integrity reserve studies. They call it Condo 3.0. I call it Condo less than 3.0 or less than zero because, frankly, it's still a mess. But they're trying to clean up some of those provisions in the Florida statutes. And listen, I welcome them to do it. Anything that's going to make everyone's lives easier is great. But this year, most of what seems to have been addressed is the HOA laws. So some of them are estoppel fees, which were something that for the last forever you could charge a fee for as long as you were you had it in your governing documents or some kind of resolution or the management contract. An estoppel is basically when someone goes to sell or mortgage their property and you go to the closing and you have to know at closing what the association is owed so that you can start fresh after that closing occurs. Either the new owner starts fresh or the lender doesn't have to worry about the owner being foreclosed, and they protect their interest by making sure that the association is paid in full. Now, in doing that, in providing that estoppel certificate, the management firm and the attorney are generally going to be spending their time and devoting time to it. And not only that, but making sure that everything is accurate and, frankly, putting their necks on the line. And so there has been a charge for that forever. There is a particular legislator that has made it their mission to do away with these fees due to what I think is a misunderstanding of how the closing process works. My understanding is now that rather than it being that you wouldn't be able to charge for that at all, and it would be an expense of the association, they've now changed it. And what's being presented at this point is that the governor would basically be considering that the estoppel fee is not something that the association can require as an upfront payment. It's something that gets paid at closing no matter how many of these certificates you prepare. So in the interim, it just gets tacked onto the account that because the owner's closing and selling the property or mortgaging it, you're probably not going through the collection process, and that's just continuing to accrue. Hopefully, you're taking it a little more aggressively, but bottom line, that is one of the laws that's out there. There are laws that are being considered as to, I believe there's one on conflicts of interest of HOA directors. There's one that passed last year. I think there are additional changes. My suggestion, and yes, there are a ton of potential changes. Go to Jeff Rembaum's Roundup. I know I refer people to his page on a regular basis on the show, but the bottom line is, one, he's my partner, so it helps me. And two, he is my partner, so I trust him, and I know that he's a brilliant lawyer, and he's going to give you good information. And I've read his legal update article as to what's pending and some of these issues. And I think that it does give a good depiction of where we're at and what we're expecting to come down the pike. I don't know how frequently that's been updated, but I would check out Rembaum's Roundup to just see what's in the hopper, so to speak, that he thinks is a good or bad idea, which, frankly, everything that I've seen, I'm just like everyone else that's a little bit of a fan of Jeff. I read all of his articles as they come out, just like I do Robert's. So I think that'd be a great place to go to get more information on these potential HOA changes.
We get a lot of letters, Alan, about handicap parking, and most of them are all, how can we get more handicap parking? Most of them are condos.
Well, I mean, you can devote new space to handicap parking. There's really not a way that you can be forced to have handicap parking that I'm aware of, unless it's required by general law. It's not you need to devote this as a new handicap parking spot. But what you are generally required to do in a disabled person to serve the disability and alleviate it to the extent of giving them the right to use the property just like anyone else would, is if there is a closer spot, you might be required to give them that spot, even to the detriment of somebody else. So like the spot that's right next to their condo unit versus the one that's around the corner and in back of the building, you may be required to give them that spot so that it's easier for them to actually get into the building. This is one of those things. I think every community should have a policy that governs how you review these types of accommodation requests, which is what we're talking about most of the time. You should have a written policy that's been prepared by your attorney, but I'll be candid, that wouldn't even be addressed in that type of policy. It would be something that you should be immediately contacting your attorney and having them guide you through the process of saying yay or nay and making the determination of whether this is something the association has the ability or obligation to allow this type of change.
Somebody just wrote in, I guess you can see it as well as I can. Alan is the best. Alan, you got to stop having your cousins call into the show.
Well, listen, I got to get some props once in a while, okay?
I hear you. Jason in Winter Gardens wants to know, if a board member resigns, does the open seat have to be filled by the members that ran for the board but did not get elected?
No. If a director resigns after the election's done. That's over. The result of that thing doesn't matter. If they resign during the election, that might be a different story. But if you have your election and then a week later someone says, yeah, I didn't realize it was going to be this much work, I really don't want to do this, there is an option to either hold a new election just for that one open spot, or the easier and, frankly, in my opinion, the better way of doing it is to go ahead and simply have the rest of the directors appoint someone to fill that spot. There's nothing that says it can't be the person that got the next amount of votes that would have been on the board if this person hadn't tried. But there's nothing that says it has to be that individual. It's not an automatic is really the answer.
You know, Alan, you always explain everything so well. Boy, you're really going to have to do this one.
Okay. I'm interested to hear what the question is.
This is from Randy in Orlando. He wants to know, can you go over the structural reserve study?
That's a 1-hour class that I teach. So the answer is not in this context. But essentially what it requires is that you get an engineer, architect, or a team that's operating under those engineers and architects to go out and physically perform an inspection of your building, the structural components of your building, if that building is 3 stories or higher. And it's basically going to say, here's what problems I see, if any. And that's pretty much it. It's an inspection that will result in a document that's going to tell you what reserves you need over the next X amount of time. If you can't tell what the reserve amount's going to be, or it's going to be more than 25 years before an individual component is expected to fail, you don't need to reserve for it. There's a lot that goes into this. I mean, I will re-refer you to Jeff Rembaum's roundup, the legal update, for the most up-to-date information. And I'm pretty sure that the structural integrity reserve studies and the other milestone inspection report comprise about half of that legal update from last year as to where we're at now. Again, like I mentioned earlier, there is a change to all of those things. Some of the information that's required, some of the requirements in general. There are changes being proposed this year. I don't know if they're going to pass or not because I'm not up in Tallahassee. But the bottom line is I would suggest if you want to know what the status of the law is right now, check out Jeff Rembaum's Roundup article. And I think it's on the top of the Rembaum's Roundup page, the legal update, that you can just click and get that PDF. And it'll go through all of this. That's going to be easier than me taking the rest of this show in the next hour and a half to try and go through all of that stuff, the structural integrity reserves and milestone stuff. I've been told that I rushed through it, and it still took an hour to present it during my legal update seminar. So just, I don't think it's a good idea for me to even try here.
I guess Jason in Winter Gardens had said that he had heard that possibly some of these new statutes will target HOA websites, and that requirements for not only HOA for the homes, but for condos too, that they were going to lower the amount of units. Is that true?
It is. Right now, there's no requirement for HOAs to have a website at all, to my knowledge, and condos, if there are 150 units or more throughout a multi-condo or in an individual condominium building, needs to have a website. What they're proposing is that HOAs, I don't recall the number offhand, but if they have a specific number of lots, an HOA would also have to have a website, and condo, it would be cut down to, I believe it's 25 units, which is a vast majority of the condos in Florida would need to have the website with all the information. I believe from my previous review of the proposed bill that it would be the exact same requirements in condo versus HOA, but it would be that more people, basically more communities, would have to have a website. And I'm going to just be candid. It's not necessarily a crackdown. It's a method of facilitating communication so that everyone has access to the records. Because if the HOA statute stays the way it is, and the Florida Administrative Code regarding HOA stays the way it is, you can basically just refer someone to your website for all records inspection requests instead of having to bear that administrative time, burden, and expense of copying your records, etc. Why would you not want to be able to have all your records accessible to everyone in the community? To me, yes, it's an association expense. Scanning all those records in is another association expense, but you save so much time in not having to produce certain records in paper form, mail them out, etc. I just think it would be easier to have a website if that's a feasible option for you. And frankly, because this has become such a big thing in condo world, a lot of management companies are offering to actually have that as part of your contract, that they'll create and maintain a website for you. So it's not even like you need to go out and find another vendor as long as your manager isn't really bad at creating that website. So I think, yes, it's another imposition, and I'm not ever in favor of more imposition on community associations. This one I think actually makes sense because the reality is it's just a method of making your records available and making the information about your community available to more people in an easier fashion.
Yeah, we get a lot of letters, people upset that the communications meetings they didn't know about, as well as a lot of the out-of-town people who own condominiums or homes, not knowing when elections are, things like that.
Yeah, I mean, it makes it easier, especially, adding to the website requirement. It's not required, and I'm not suggesting that they make it required, but people that adopt electronic notices and electronic voting, they get everything on their phone. You don't have to worry about whether the association has the right mailing address and this and that. You're verifying it every time a vote's coming up that you've got the right address. So I just think that it's a lot easier to do these things electronically. And frankly, it tends to save your association money, which in turn reduces your assessments, which I think it was the last show we did together, Steve. Those assessments are skyrocketing for everyone across the board between the cost of insurance in Florida. And by the way, I saw that there were 2 or 3 new insurers that have finally started entering the Florida market. So thank goodness for that. But, the milestone inspection, structural integrity reserve studies, the additional expenses in HOAs, the cost of living increasing, all of this is causing your assessments to go up. So why would you not want to do something that causes them to go down?
Right. Exactly. Exactly. Um, if you don't mind, we've gotten two or three people write us. Can you go over your schedule again for March?
Sure. Let me pop that back up. We've got Venice, the Lunch and Learn on March 1st with Kirsten Henza. And all of this, by the way, just go to kbrlegal.com on the calendar. You can register directly from the website. Very easy. Fair and consistent HOA violation enforcement with Emily Gannon on March 6th. The CAI FLA legislative update on March 15th with Lisa McGill. Miami-Dade happy hour with Covenant CEU credit at Roots Chris and Coral Gables by Mike Bender. Screening process, develop procedures, and train your committee is Allison Hertz, hosted by CAI Gold Coast. That's going to be on March 20th. Also March 20th, HOA board certification with Danielle Brennan, hosted by Campbell Property Management. Community Association collections, should I pay or should I go? That's one I'll be teaching on March 26th. The 27th is condo board certification with Andy Black of our Pompano office. That one's also hosted by Campbell Management, and that's going to be March 27th. And the 28th, Kirsten Henza, hosted by Synovus Banking, is funding construction projects, loans, assessments, and reserve spending. So that's what we've got coming up. We're also going to be at the Tampa HOA and Condo Expo on April 1st, the Broward one on April 3rd, Palm Beach on April 10th, and Orlando is May 21st. Apparently, they make us wait the longest because we're just the best.
Well, I don't know if you're going to like this one or not. This is from Will in Orlando. How come your show isn't every week? I love the show. I guess we should take that as a compliment.
We will.
He wants to know also, when I have a water issue with the unit upstairs, the person above me wouldn't fix the leak. My contractor said it was from the water upstairs. How do I get him to pay for it? The leaks were from the sliding glass door.
Sounds like an insurance claim to me.
Yes.
Either file an insurance claim or potentially, I know an attorney that does those cases very regularly in South Florida. I don't really know anyone locally that does that type of neighbor to neighbor issue that doesn't involve the association. But I can recommend possibly a few people if you want to reach out to me directly. I don't want to name names over the air, so to speak, just because I don't know if they want me recommending them. But the bottom line is, I would start with potentially an insurance claim, even on the neighbor's insurance possibly, and let the insurance companies duke it out. That way you're not out of pocket. Most attorneys that are going to do that are going to do it on contingency. So you won't be out of pocket most of the time for attorney's fees and costs, but the insurance company, as strange as it may sound, might get it resolved faster than just filing a lawsuit against your neighbor.
Okay. Here's a developer question HOA getting ready to turn over the development. What if there is no money in the bank? Is there a checklist of what to do before the developer turns the property over to the board?
Yeah, so there's a checklist. Step 1, get a good attorney. Step 2, have your attorney tell you exactly what you need for your particular community. That's the checklist. Because the bottom line is that's not, yes, there's a list of standard items that the developer needs to turn over. It's in the Florida statutes once that turnover process occurs. I'm not going to say that doesn't exist. But the bottom line is it's not going to necessarily tell you that the association should go out and get its own engineer to make sure that everything was done properly, get an audit performed to make sure that it's on your own and not the developer's auditor who they pay to do hundreds of these and who might be inclined to necessarily benefit the developer in the event that it's not clear how an issue should go, et cetera. Bottom line, you're going to want to consult with your attorney as to the turnover process and what the association really needs to be doing to make sure that you're protecting not only the community, but protecting the interests of each member of the community from the developer. Now, that's not to say that there is something the developer did wrong in every community. I'm definitely not saying that. But you're not going to find out, most likely, from the developers' contractors who are going in and doing these reviews. That does happen. I'm not saying it doesn't, but it's more likely that there's going to be a problem that is actually located if you hire your own experts to go out and do those reviews of what the developer did right and wrong. So that would be the most important thing I can suggest, is get your own experts, get your own contracts, get your own contractors.
Alan, I'm going to ask you a question I've asked you before in the past, and you answer it so well. Why should my board hire K. Bender Rimbaum?
Well, first of all, there's me. But second of all, you know what? I just think that we provide solutions rather than just answers, which a lot of firms, especially in this industry, don't do. We specialize specifically. We've got I can't say experts according to the Florida Bar, but we've got multiple individuals within the firm who are board certified in this area of law, who are designated as specialists by the Florida Bar. This is all we do. We're not masquerading as a firm that does HOA and condo, but we really do real estate. This is a specialized area of law. There are maybe 10 to 15 firms in the entire state that do this as their main business. And I just think that we do it better than anyone else. We offer, I think, better client services, more education, and frankly, more direct answers. I came over here and started working with Robert Kay after a couple years away. And I found that his writing style, which he has shoved down my throat in the best possible way, is just so much clearer and so much more client-centric than the way that anyone else that I've ever worked with has written. It's just, here's what you asked, here's the facts you gave us, here's the answer, and then all the legal gobbledygook. So we're giving the answer up front. And I don't think many firms do that. It's, hey, I billed you to write all of this stuff. You better read through it all and take advantage of that. The amount of time that I put into this before I'm going to give you the answer. The other thing I think we do better than anyone else is actually answer clients' questions. We do what the client is asking if it's within our power, rather than just, well, here's what I think is important, which is what I've seen from firms that I work with in the past. So, I mean, I'm not going to sit here for 45 minutes and tell you what I think is fantastic about our firm and better than all the other ones. But I genuinely believe, and the reason that a year and a half ago I did immediately reach out to Jeff Rembaum when I decided it was time for a change, is because I know exactly how our firm operates, and I don't think that there's anyone that truly competes with us.
Well, I know why they chose you to represent them on the shows. The website is, we keep talking about, is www.kbrlegal.com. And Alan, give everybody the phone number one more time.
Sure, 954-928-0680. That's the front desk in Pompano, and you can use that number to reach literally anyone in our entire firm.
And Alan will be back again with us next week. It's always the last Thursday of the month at 5 o'clock. So we'll see Alan again next month. Bro, I love you, man. I love doing the show with you.
Really enjoy it every time. And thank you, everyone else, for attending as well.
K. Bender Rimbaum. Thanks, Alan.
Thanks, Steve. You have a good one, buddy.
You too. That's it for us today. I love doing the show with him. And I got to tell you, if you are a board member, I am telling you, K. Bender Rimbaum, you want to at least talk to them. Maybe they can give you some new ideas. We'll be back again with you next week with more Ask the Experts.
Thanks for tuning in today to the Ask the Experts show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.